Once again, good morning, everyone. And as I discussed in foreign filing license, last class we have understood that the purpose of foreign filing license is to see if if an invention is relevant for defense or purpose or atomic energy. If it is yes, then yes, uh, uh, there can be a secrecy direction as required. Now, how to get that time? They have provided for this section, and they want at least a 6 weeks time from the filing of your application. So no application can go outside by an Indian resident without informing controller, unless the same application has been filed in India and 6 weeks have passed and there is no direction has been given under section 35 to them. They can freely go and file everywhere. Any violation of this, any variation of this, you have to take the permission. Rule 71 says that form 25 should be used to make the to get the foreign filing license. Then controller shall dispose of request within a period of 21 days from the date of filing of request, and if it is related to defense or atomic energy, from the date of receipt of consent from the central government. Okay. Now, see, if you remember in 2, it was that every such application within such period as may be prescribed, the controller shall, this is the section 35.2, 39.2, sorry. 39.2, it says that controller shall dispose of every application within such period as may be prescribed, provided that if invention is ratified this, the controller shall not grant. First thing is within such period. What is the period? 21 days from the date of receipt. Proviso is that if it is relevant for defense and atomic energy, controller needs the consent of central government. So the period will become 21 days from the prior consent of the central government. Remember, when we were discussing earlier how the timelines are important. In timelines, you have to know from which event the timeline will begin and or at what event or after expiry of what, how many days that window will end. So this is how it is in this scenario. Okay. Next, again in 118 it talks about any contravention of secrecy provision, that is under section 35 direction or section 39 application, or that is foreign filing license. This will be punishable if you violate that, imprisonment of 2 years or fine. 118 talks about it. Now see, start remembering the sections. Everyone has a problem, so you always say the section 35 secrecy directions. That way, whenever you are referring to the secrecy direction, use section 35 secrecy directions. So you will be okay with that. Section 35 deals with the secrecy directions, or section 39 application in form 25. Okay. That way you remember the form also. Whenever you are discussing, try to discuss it in such a way that it gets repeated again and again. So section 39 foreign filing license in form 25 is filed to get the foreign filing license, and when it is needed to file, this is how you revise it again and again. So you will not take more time to remember it later on. So start revising and repeating the section which you are getting exposed to, and try to make a connection. For example, I will ask you, last time we have discussed, what does section 2(1)(y) define?
True and first inventor.
Correct. And what does section 2(ab) defines? 2(1)(ab) defines A, B, assigning of B. It defines assigning.
Yes. Assigning, yes.
Okay. So remember, this is the connection I have made. Keep repeating it. What does the section J defines? Section 2.
Invention.
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 And JA?
Inventive steps.
Correct. So this is how you keep on revising again and again. If you have made a connection, reinforce it. The more you reinforce it, in last moment you will not be stuck कि ये section याद नहीं हो रहा है, ये definition याद नहीं हो रही है. Correct? Start now. Shailin, you are here, right?
You are here, right?
See,
See,
start revising. Start slowly doing this. Okay? Otherwise, a daunting task in the last. वो हिंदी में कहावत है, बूंद बूंद से सागर घड़ा भरता है. तो बस start with this drop only. Okay? Now, another part which we have discussed earlier was patent. There are patent offices. In patent offices, there is a CGPDDM who is supervising the entire patent office, who is appointed under the Section 3 of Trademark Act. Trademark Act. Now there are four patent offices. Where is the head office of patent located?
Kolkata,
Okay. Where CGPDDM sits?
Mumbai,
Correct. So that means his office is there, but head office is in Kolkata. Now, if an inventor is coming from Andaman and Nicobar, which jurisdiction will it be?
Kolkata,
Correct. If it is from Pondicherry,
Chennai,
Daman and Diu,
Daman and Diu also Mumbai,
correct. So now this is how it is. If it is from Bihar,
Kolkata,
good. Only one person is answering. No one else has revised. Please go through that. Okay. Okay. Now, let's start with the applications of the patent. We know who the applicant is. Applicant is a true and first inventor. He is a signee or legal representative if inventor is deceased. These are the three criteria. Now, we start with the form of application. Section 7 deals with this. Applicant is dealt in Section 6. Now, what it talks about, every application of patent shall be for one invention only and shall be made in the prescribed form and filed in the patent office. The first section talks about three things. First, one invention, one application. Second, it should be made in the prescribed form. That is, the prescribed form is Form 1. And it should be filed in the patent office, that we discussed, with respect to, depending on your address or place of business or address of service, it will be determined which patent office will you file. Now, 1A and 1B, these two relate with the international applications. What is an international application? International application is defined in section 2(1) IA. See, IA, international application, abbreviated form, related with that. Section 2(1) IA, international application. International application means an application for patent made in accordance with the PCT. That means we are not talking about convention application here. Every international application made under PCT for a patent, now to summarize, I will always refer it as an international application, as may be filed designating India shall be deemed to be an application under this act if a corresponding application has also been filed before the controller in India. Correct. Just to understand it, see, in PCT what happens is, first an international application is filed and then you decide in which territory you want to go for the patenting. One application in different jurisdiction, you can go with that application. The day you file it, from there you get 30 to 31 months depending on the understanding of jurisdiction in which you go to in the national filing phase. So what does this is, from international filing, international filing date, the date you have filed this international application with receiving office or international bureau, that is WIPO. So if that is done, within that, unless you have designated the India your international application is of no value to patent office in India, because you are not coming to me, coming to my jurisdiction. But if you are coming to my jurisdiction, that means that international application, corresponding application when it is being filed, then that particular international application will be deemed as a Section 7 application. It will be as good as the application filed directly in to the Indian Patent Office. That's what we are considering here. So the we also refer to the national phase as PCT NP phase application, national phase application. Okay. Now, just for our understanding, now the filing date of an application referred to in subsection 1A and its complete specification processed by the patent office as designated office or elected office shall be the international filing date accorded under the PCT. Now, what he is talking about, 1B says how I will determine the filing date. See, now there is two dates, right? One is the date on which international application was made to the WIPO, International Bureau, or any other office which is any other jurisdiction which is designated as a receiving office, means any office which can receive the application of PCT under PCT. So suppose there is one date, there is another date on which you are entering the national phase. So you will be filing a proper proper application with respect to requirements of that jurisdiction. So you say since there are two dates, we will always consider the first date, that is the filing date of application to the filing date of application to RO or IB as the filing international filing date. This is how it will be. Okay, that is the international filing date, and we will continue with this. So, what is the importance of filing date? Importance of filing date is because various timelines begins from that, and most important part is from the filing date your term also begins, term of patent. Okay, so please understand the importance of all the dates which are coming in picture as and when we are discussing them. Now, here any
Sir,
question,
sir, yes, I have, sir, one question for clarification.
please.
So when any application comes to India through that PCT route, and like when from the US it is coming, so when they are filing the PCT, that day will be counted as the priority date. Am I right, sir?
Now, I have not talked about priority date.
Okay, filing date.
Yes. Don't confuse priority date with filing date.
Okay.
Okay. This confusion will create lots of problem. I'm talking about filing date. Filing
Okay.
date is saying the international filing date shall be the filing date of an application. And
Yes.
that international filing date will be which is accorded under PCT. I'm
Hmm.
telling you international filing date will be the date on which RO or RO means receiving office or international bureau will has received the application. That means
Okay. Okay.
where PCT application was first filed, that date of filing. Priority is a different scenario. Whenever we are talking about priority date, we are talking about the date at which my novelty has to be established, my inventive step has to be examined for.
Okay.
That will be a cutoff date at that time. So I'm not talking about the priority date at such.
Oh, okay. It
They
will come later.
it will
Okay.
come later. Filing
Yes.
date can be priority date, can be same as the priority date or it can be different.
Hmm.
But let's not confuse it here at present. Remember,
Okay.
filing date is fixed. Filing means the date application has been received.
Okay. To the international, like in India, I have to apply in Delhi.
In India, you have to apply in Delhi means I didn't understand.
Delhi is the receiving office for the PCT
Yes,
applications.
yes, 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 yes. Correct.
So my next question is that the terms of patent you are talking about, like if anything through PCT route comes to India, and like when it will be started, the national phase from the national phase entry date or the filing date, 20 years.
20 years will be from international filing date. No?
Okay, international filing. Okay,
We
okay,
will
thank you,
discuss
sir.
when we are discussing the terms. I remember it that it is from international filing date only. See,
Okay,
in between you have that. See, you are getting when I will discuss the international application, then you will know why we are talking about the timings. The timings why that why you are getting a little more time than what is prescribed in the domestic application. That's it. Say request for
okay.
examination can be filed within 48 months, right?
Yes.
So I am giving you 4 years here from the date of filing. Similarly, from
Hmm.
international filing date, when you are entering here and apply for this, then also you are getting the 31 days to 31 months to enter the national phase in India.
Hmm.
It's still below 48 months.
Yes.
So this is how the concept is related. But don't get
Okay.
confused there at present. Focus on what I'm teaching here. See, uh, what I'm telling is let's walk one step ahead. You might be knowing exposed to various procedures. Once let me finish that concept, then go to that. Otherwise, it will confuse the class.
Okay, sir. Okay,
Okay.
sir.
Okay. Now comes so where the application is made by virtue of an assignment of the right to apply for patent for an invention. What I'm talking about here, I'm talking about true and first inventor can assign its right to apply. If assignment has been done, that has to be proved and a document to that aspect has to be provided. Document will be considered as the proof of right. Okay. Now, how that proof of right will be done and in what period it will be prescribed, we will discuss later. For that, we will refer to rules. Then comes every application under this section state that application is in possession of the invention. There will be always be a statement that applicant is in possession of invention and shall name the person claiming to be the true and first inventor, and where the person so claiming is not the applicant or one of the applicants, the application shall contain a declaration to the that the applicant believes the person so named to be the true and first inventor. See, now the what are the statements required? The applicant is in possession of the invention and it, it shall name the person claiming to be the first inventor. When true and first inventor is not an applicant, the application shall contain a declaration. When are you needing the declaration? When he is not the applicant. True and first inventor is not present itself in the applicant as an applicant. Declaration that applicant believes the person so named to be the true and first inventor. Who is giving this declaration? Applicant. Who is giving this statement? Applicant. So please remember it talking about the possession. Applicant is in possession of the invention and name the person true and first inventor. And where the person so claiming is not the applicant or one of the applicant, then declaration. This will always be there, and if he is not the applicant, then a declaration has also should also be there. Now comes every such application not being a convention application or an application filed under the PCT. So what I'm talking about, every such application, but I have created this uh, bracket just to make it clear. Every such application, this is an exception. So every such application shall be accompanied by a provisional or a complete specification. Now, what is the requirement? Please understand. First requirement I am saying, patent should be formed in a prescribed form. Form 1 is the form. Then we are talking about if there is an assignment, inventor has assigned the right to apply, that proof of right should be submitted. Third part which I am talking about is that if an application, there should be some statement and declaration as prescribed in the first section 7.3. Now in 7.4 I am saying if that any application which is not a convention application or a PCT, then it should be accompanied by a provisional or complete specification. The form prescribed for filing of a provisional or complete specification is Form 2. So Form 1, Form 2, proof of right and declaration possession we will just see. Come to this statement. Just one application, one invention, prescribed Form 1, proof of right, right to apply for patent for invention has been transferred. Statement of application, possession of invention. Please remember, you can be asked what right is being transferred by true and first inventor to applicant. This is the right to apply. Okay. If true and first inventor not an applicant, declaration the applicant believes that believes the person so named to be true and first inventor. Application plus specification, provisional or complete, should be filed in Form 2. What is the exception? Convention application or international application designated in designated India. International under PCT application which are designating India shall be considered as an application under this act, under this section actually. Okay. हो गया. Now rule 10, proof of right assignment, or the root proof of right will be what? The same thing is talking about in an application for patent made by virtue of an assignment of right to apply for patent of invention. If an assignee is filing, assignee of application, applicant is nothing but is an assignee of the true and first inventor, then a proof of right should be submitted, and it should be submitted along with the application. See, it says if not furnished, you can furnish it along with the application or within the 6 months after the filing. Okay. Okay. Now he is talking about if it is an international application, then the 6 month will begin when the PCT NP phase filing is done, not before that. Because if you are not entering in India, then you don't need to tell me anything. So when you are entering in India, from that date, when you have filed the PCT and P phase application, from that date, 6 months, within 6 months, you can permit the proof. Okay. So this is, we understood what are the documentary requirement with respect to this. We will discuss all the documents a little later. There is another document which is required, so I'm talking about section 8. Now,
Here I have two questions relevant to that. So, sir, that means from the national phase entry, 6 months time we'll get for submitting proof of rights.
yes, correct.
Okay. And the second one, sir, for convention application, according to Patent Act, that is not applicable. Only for PCT things it is applicable. Section 7 is talking about that.
See, when convention application is being filed, it is directly being filed in India. So there is no different date. So date of filing
Okay.
plus 6 months. Here is talking about that since there are two different dates. So he's talking about first filing date and another filing date. There are two filing dates. That's why
Okay.
he's talking about which filing date you will take.
Okay.
Okay, clear?
Okay.
Okay. Now come to the section 8, where an applicant for a patent under this act is prosecuting either alone or jointly. The you read, if entire you will read, it talks about that if any applicant is filing outside India, or whether alone, whether jointly, whether the invention is same or substantially the same. That means a variation of the invention also is getting covered here. where to, or he has the knowledge that this application is being prosecuted by some other person through whom he claims, or by some person deriving the title from him. So either way, if you are related directly or indirectly, if you have assigned it, then also, either way, you have to file along with your application or subsequently within the prescribed period. As the control may allow what? A statement detailing the particulars of such application, that I have filed this application, this is the application number, this is the date when it is filed, this is the office where it has been filed. This kind of details has to be provided. Then you have to also undertake what? That up to the date of grant of patent in India, if any application is filed outside India or whatever the particulars is there, you will be filing the statement to us, to IPO, Indian Patent Office. This is the your responsibility on your own. That is, I am an applicant. Because of me, some application is getting filed in foreign. There is a foreign filing because of me. Now, but I will file a section 8 statement and undertaking. Section 8 statement says कि whether I have at present filed whether I am going to file a foreign application or not. If at the time of filing you have a vision, you tell that this number. Whenever you get the number, you file that this patent application I have filed, this is in foreign jurisdiction. You keep us informed. Then another undertaking, whatever the development there will be, I will inform you about that. Then comes second part. Controller can also ask you to furnish the details. And this entire obligation undertaking which you are taking is till the patent is granted. Now, if you understand the concept why it is there, is simple. Our concept of novelty is global novelty. That is all absolute novelty. It should not be published anywhere in the world. So the question is, patent office is saying, if you keep us informed in the where your patent application is getting examined in other jurisdiction. Because of my knowledge to that, I can also refer to them or ask details the whether what happened with the examination report from there. So they can get to know whether they have missed a novelty or not. So this is to help them in the prosecution. That's why this requirement ends with when you get the patent or your patent is refused. Okay. So now we will see all the forms. Form 3 is the section 8 statement. Now, simple thing is, if I am filing a foreign application for same or substantial application, or in either way, directly or indirectly, which has been covered here, then I have to file a statement. Whether I am filing or not, both. I am not filing in foreign application, that also has to be informed. And then undertaking has to be given. If I file any foreign application, I will keep the controller IPO updated with respect to foreign application. And controller can ask details with respect to foreign application. This is the main requirement. Now comes Rule 12. Rule 12 says in Form 3 you have to apply, and then it talks about कि shall file a statement undertaking 6 months from the date of filing of application. Within 6 months you should file. Now so when your 6th application goes, suppose once first you filed, at that time you declared I have not filed any foreign application and I will keep you updated. This is the first time. After first time, let me rephrase and give you a timeline. In January, suppose you started on 1st January 2023. But that day you made a statement undertaking, both were correct. After that, in February, you decided to file. And in March, sorry, in February you cannot file. In February last week you can file. In February last week you decided that I will go for foreign filing license, and in March you filed the sorry, foreign filing license. I'm very wrong. Foreign filing of the application. When I'm filing the application outside India, then that date. Suppose it was done on the 2nd March 2023. Then from this date, within 6 months, I have to submit another Form 3. That for updating. Okay. For the purpose of the period to use this. The time within which the applicant for patent shall keep the controller informed of details in respect to other is this 6 months from the date of such filing. Okay. Same thing. Here what it is talking about, had it been an international application, unless you enter, this liability will not trigger. The date of filing of national phase application will trigger the liability of keeping me informed, and within 6 months, that 6 months, Form 3 you have to submit. Okay. The explanation is for that. Now comes, if I am asking, if controller is asking, then you have 6 months from the date of receipt of that communication of the controller. You got the controller's date of such communication you take, that is the milestone. From there, your 6 months begin. Is this clear? Okay. Now, let's go to all the forms, documents which are required. Now the document requires application for grant of patent, Form 1. A proof of right from the inventor in favor of applicant, endorsement in the appropriate paragraph of Form 1. It can either be in the form of endorsement or there can be a proper assignment agreement. Both can be used as a proof of right. It should be filed within the 6 months from the date of filing, or if it is endorsed, fine, or it can be along with the application also. Provisional complete specification, Form 2. Then statement undertaking, Section 8, Form 3. Along with application for or within 6 months. Keep information to controller within 6 months from the date of filing of such foreign application. Okay. Now, declaration as to inventorship. This is a Form 5. I am the inventor, that declaration has to be filed under Form 5, and along with the complete specification it should be filed. That means if you are not filing the provision, your complete specification at the time of application, then you can file Form 5 with a complete specification. But whenever complete specification will be filed, declaration as to inventorship should be filed. Now comes form of authorization. You are authorizing another person to file the form, that is a patent agent. A power of attorney of Form 26 has to be filed, and it should be filed within the 3 months from the date of filing. Then if you request for any extension of time, for example extension for time for filing of declaration of inventorship, now it can be extended for 1 month at a time, and it will call Form 4 can be filed. Then comes, as we have already discussed, Form 28, SME, startup educational institution. If you are claiming that there should be a reduced fee because you fall under this, then please go for Form 28 and you file that. Priority document, we will discuss what is that. A priority document is, there is a priority document is claimed document on basis of which the priority is being claimed, that has to be filed. I've said that within 31 months from the date of priority, I will just recheck it. I have to recheck it, please. Before circulating, I will recheck it. Okay, under which rule it is. I think it might be a typo. Okay, before that, now I will show you all these forms and how they look when the this. See, this is the form 1 which has been filed. Open. See, this is much better. Now, form 1, this is a file form. First thing, type of application, ordinary, convention, or PCT-NP. PCT-NP is the PCT national phase. Now, both can be of divisional patent, convention divisional patent, PCT divisional patent. Now, applicant's name is there, requirement as provided there, category of applicant is, the applicant has claimed that he is a startup or a small entity, whatever, here it has claimed the startup. Now, inventors, their nationality, their country of residence, their address has been provided. It's asking all the inventors same as the applicants named above. If inventor and applicant are same, you are saying no. The moment you are saying no, what happens is you are required to submit a proof of right. Now the title of invention, authorized registered patent agent detail, and then address of service has been provided. In case of application claiming the priority, there is no priority claim. It's not a PCT application, it's not a divisional, it's not a patent edition. Then comes declaration. See, this is a declaration by inventor. We, the above named inventor, is our true and first inventor for this invention and declare the applicants herein is our assignee or legal representation. This is the declaration. This is also can be understood as a proof of right. Or declaration by the, now the declaration by the applicant in the convention country, not needed here. Declaration by the applicant, this is what they are declaring. We are in possession. Complete specification related is filed. The invention as disclosed uses the biological material, it's not applicable. No lawful ground of objection to grant to it, that is also there. We are assignee or legal representative of true and first inventors. This is a declaration by applicant. Now, the application this, we claim all this is not applicable to them. This all, we will see, this all is relevant and comes from a substantive provisions and reflects that. We will discuss and then we will revisit the form and you will be noticing why these are here. Now, attachments is talking about form 2. It's talking about the number of pages in which how many numbers of pages are in complete specification, how many claims have been filed, how many pages have been used. Then see, number of claims and pages are important because fee may vary based on this. Then comes abstract, number of drawings. Then statement undertaking of form 3 has been filed, declaration of inventorship in form 5 has been filed. Then power of authority and entire thing. This is how the form has been drafted. This was the form 1. Then this is the proof of right. They have submitted it with proof of right and they have used the form 30 to submit it. They might have delayed it. That's why. Now comes simple. See, in this executed, declaration is executed. This is considered as a form proof of right. Hence, this is being used. Both inventors have signed here and that will be considered as a proof of right. Now, complete specification is filed in form 2. We will discuss entire this when we will discuss the drafting of the specification and the claims. But just for your knowledge, this is how the format has been prescribed and this is how entire form 2 looks like. This is the description, disclosure, and then this is the claim. Claim always begins from we claim. And this is how it should be numbered and properly drafted. Then comes abstract. This is the abstract of the invention. Now comes section 8. We are talking about form 3. Form 3 is the section 8. Here, what they have submitted, I'm not discussing it. I will discuss the entire form 3. Now comes to form 5. Form 4 is for extension of time. So it does not need to be filed with this application. Now comes form 5. Form 5 is declaration as to inventorship. See, this is the declaration as to inventorship which needs to be filed along with the complete specification. The name of applicant, here true and first inventor of the invention, disclose the complete specification filed in pursuance of my application number this, dated this, and these are the inventors. Okay. Done? Now, this is the patent. Form 26 talks about the form for authorization of patent. It should be executed on a stamp paper. So, a stamping is done because otherwise stamping is required as if the power of attorney is being executed. Same power of attorney duty is applicable. Generally 100 rupees depending on the jurisdiction, state jurisdiction, what state has prescribed the fee for that particular state. Now, Form 28, startup has submitted this, that I am a startup, and along with that, the proof of certificate of a startup. See, I am a private limited company, incorporated, registered here as this, date of issue is this, place of issue is this, and at that time, the certificate had the validity for 5 years. Now it's still 10 years. Turnover was this. Now that has also changed. Then comes Form 9, that is the request for publication. So now till 528, this is filed at the time of filing of application. Now what I am going to show you other forms just to complete the life cycle of patent as we have discussed in earlier classes. Now you request for publication, you file a request for publication under Form 9. Now very easy, you can correlate with another step which is called examination. Double the number 18. If you file the form 18, then the form 18 will be the request for examination, and 18A is for expedited examination. See, they have filed for the expedited examination. They have requested that it should be examined under these sections 12 and 13, and how can I, what gives me a right to claim the expedited examination? Because I'm a startup and this is all. Okay. Now, then after that, examination will be done. The first examination report was given. Now I have a question. The application number talks about 20194101373713. Can you tell me what can you decipher from this? What information can you get out of it by looking at this application number? Yes. Anyone?
Yes, sir. 2019 is that application year. 4 is that patent office, Chennai. 1 for ordinary application. And that last 6 digit for that year, it is from coming from patent office.
The number of the application, correct. So please remember this. I have not seen any question with respect to this application. First though, just for your information, you might get a question on this also, but just for your reference, it is easy for making understanding which application, where it has been filed and what is being done. Okay, now comes, see, the examination report is here. We will discuss it later when we will discussing the entire examination procedure. But just see, this examination report is a sample what is important. Don't go with these details. Go with these details. Date of filing, date of priority. Okay. So when you are understanding, you should understand what is different between date of filing, date of priority. Then PCT international application date, number and date. Had it been a PCT, then his international application and date will have become, and this date would have again been important, right? This date of filing and this would have been different because it would have been the international application date. Now comes the applicant number. Then request for examination when it was requested. Then date of publication when it was published. See. Then comes summary of report. In summary of report, this is the under section. This is what we are checking: novelty, inventory step, industrial goods, and I'm checking whether that claim, in which claim it is considered novel, and in which claim it is not considered novel. So this is how it is. Then non-patentable criteria. That is section 3, which subjects, which subject matters are not patent, not an invention or not patentable. This is here. Then this is the requirement with respect to claim. Claim should be clear, concise. They should have a definitive, and they should be supported by the description and the scope. These are the 4 criteria on which this is getting checked. Then detailed report is there. What patent literature he has searched. This is the prior art cited by the patent office. Then comes, see, prior art is 16, 18, 17. Application was in 19. Then comes inventive step. Then he's talking about D1, D2, D3. Teachings of these can be combined and get it done. Now it's talking about the inventive step. Okay, how these are the teachings, and this because of which a inventive step is missing in that. Then non-patentability, as discussed earlier. This is the serious prejudice to animal life. They are talking 3B is the core. Then sufficiency of declaration, they are talking about this is missing, abstract should be properly drafted and submitted. Now the scope mein, they are again suggesting some drafting changes. Then comes other requirements. Amendment, if you are trying to amend, how should you do? While amending, what care you will do? This is what they are talking about. Now, other formal requirements is the formality is being checked. Ki the drawings you have submitted, but they are not in a proper format. Statement and undertaking, what say form 3 details. It looks like incomplete, so they are asking again. Other deficiencies they are talking about. Okay, blank space complete should be scored. These are other deficiencies they are asking that this should be taken out. Then comes documents on record. They are just telling what you have submitted on basis of which this has been prepared. They have enumerated everything, what you have done. This is how it is. Now, after the FER, response to FER is filed. This is the response to FER which was filed. They are responding to all the summary of report, detailed technical report, this entire thing, and then formal requirements. They will say what they have done with respect to that, and then all the enclosures mentioned. This is how response to FER is filed. Then comes marked up and clean up copy. This also I will discuss how this is a requirement. Claim should be in track as well as clean version. Then comes the intimation of grant and recorder. This is you were intimated that this has been, you have been granted the patent. This is how you got this document. This was you are intimated and grant, and recorder of the grant has been done. Intimation of the grant and recorder. Recorder means your right has been recorded in the, your invention has been recorded in the patent register. Now, this is the patent certificate which you get. Format has been changed a little. Now it's tricolor. Earlier it was like this. Patent number, application number, date of filing, patentee who is, and this is how it is. Okay. Then regular compliances, working statement has been started and working statement is filed in Form 27. So please remember, you have been exposed to various forms Okay, till date, and start remembering those forms. Now, this was the form 25. See, form 25 talks about, you state the title that we are in possession of invention for this. Then you declare that whether you have application, we have made an application for a gun, that is, if you have filed an Indian patent application, or if you have not filed an Indian patent application, then you are talking about the brief description of the invention. You are telling this if you are filing Indian patent application, because you are requesting the foreign filing license before the expiry of 6 weeks. Name and address, we are hereby attached, and brief description of the invention. This is name and address. You will tell, you are again saying that intend to make alone or jointly with whosoever you are. This is the countries where you will be filing, name and address of assignee, who this has been assigned, and आप बता रहे हो in why you should be granted the FFL. The reasons for making this application, the reasons for making this, why I'm making this application to you is this, right? That you are an Indian resident and you are filing this, you are expecting to file this in foreign jurisdiction, or you are not taking the Indian application in here. All those things you can mention why this FFL is required. Now, last time was this. Let's discuss the form 3. This is the form 3. Form 3, see, first is the declare, second is the statement. The statement is that we have not made any application for the same, substantially the same invention. Or you are saying, we who have made this application dated alone jointly made this. If you have filed a foreign application, then this is how you should, these are the information you will tell: country, date of application, application status, publication, date of grant. Then addresses of assignee, the rights of application is assigned to this, and you will undertake that up to date you will keep this controller updated. This is the undertaking you have done. And then signing of applicant or patent agent, natural person who is signed, name, and that's it. This is the format. Form 3 for section 8 undertaking. Then comes section 5, that is the declaration of inventorship. As we have discussed, seen there, but this is the format. Please do see this format. When you have time, just go visit and read it. Declare that true and first inventor of the invention, disclosing a complete specification, find in pursuance of my or this is this. So you are telling that this application number is there on that date, and these are true first inventor. Their name is written here. You sign it. That's it. Declaration to be given when application in India is filed. Well, this is when convention country is there. Then declaration as to inventor should be to be given like this. Right? Then comes a statement. What is the statement? We assent to the invention referred to the above declaration being included in the complete specification filed in person of this. You have assented. A stage of additional inventor who is there. Done. So this is the declaration of inventor. This statement is what? This for talk about when there is an additional inventor, when that additional inventor was being is added later on. That means when I was filing, then only 2 inventors was mentioned. Later we found that there was third inventor also, so he can sign here. We assent to the invention this, and that's how it is done. So form 5 will help there also. We will discuss it again when the provisions will come. So, and this is the authorization of patent agent, which is the form at prescribed. Please see. Patent rules, form for authorization of patent agent and any person in this proceedings. Please remember, it talks about all notices, requisition, communication relating there may be sent to such person at the above address. That means I am saying all this should be sent to my patent agent. We hereby revoke all previous authorization. That means no one else is authorized at present, and we hereby assent to the action already taken by the said person in the above matter. It says that it can be issued by post facto. Why this is here? The reason is simple, that power of attorney can be submitted within 3 months from the date of filing. So before that he has done something, so that action can should also be assented to, right? And very important to be stamped on the Indian Stamp Act. So it will be stamped as a power of attorney. Stamp without stamping, this will not have a value, and you will face a objection from the patent office. This is how it is. Okay, done. So today's session we will discuss till here only. Go through the patent applications, patent application, and all the documents, forms, and other things. In next class, we will discuss on the types of application and the differences. Just